Welcome to Defense Diaries. I am your host, Bob Mata, and I am joined by my beautiful, brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, y'all.
So, look, man, I thought I was out. I thought I was out of the Reed thing. Thought I was out until, like, if and when they go and try her again. And then, you know, we're sucked right back in. So, latest thing, and this is actually very interesting, and it's kind of a fascinating topic, to be honest with you. So if you're not aware, which you absolutely cannot be paying any kind of attention to the Karen Reed case if you don't know that it was declared a mistrial last week as the jury was hopelessly deadlocked. Well, what does that mean? That's where the problem's arising here. So today, in Allie and I, we went back and we watched the end of the trial when Judge Bev declared a mistrial, and you know she didn't say much. She didn't ask any questions, and you know who else didn't say much?
The defense.
The defense. So
and they definitely had an opportunity to. They could have objected. They could have asked the judge that, Your Honor, I think we need to bring the jury back in, and you can ask them. You know, did they reach a verdict on all counts? Were they undecided on all counts? There was time, and that's what I think we should do. And it also gives some people a chance to get in here before we start reading. I sent you a link, so it's real short. Let's go to when she brings the jury back in, because you'll note, and they outline this in their motion, in their affidavits, the judge had not given them an opportunity to read the last jury note before she brought the jury in and just read it out loud. So, but they did have plenty of time to talk afterwards, even though she did abruptly end it and dismissed the jury. So maybe there's an argument there, but they could have still said something. The jury hadn't been gone. She said, "Stay in the back. I'm going to come talk to you." So I think we start with that. Just to remind ourselves of, I gave you the time in there too.
Oh, you did?
Yeah, right. It's I've got it though. It's 5:52:03.
Okay. 5:52. Yeah, I mean, she's only on the bench for like a minute, like when she declares the mistrial. All right, so I'm gonna pull it up. So again, this is when it all went down. This is after she gave the Tui Rodriguez charge, and they went back. Let's say they deliberated for another couple hours.
Yeah.
And this is what happens when she calls them back. Let's see my full screen. All right, let's go full screen here.
She just walked in.
22-117 Commonwealth versus Karen Reed.
All right, the jury is at an impasse. So we'll bring them in.
In theory, they could have spoken up right there and said, "Wait, Your Honor, before you bring them in."
I mean, or when they're in there. I mean, they could ask the judge if she could ask.
Yeah, I think it would have been appropriate to wait till they left to ask.
Either way, I don't think it's an inappropriate question. You're not asking for a count. You're asking if you can ask the jury what they're deadlocked on. So you are deadlocked on all 3 counts. Like, that question alone changes this whole motion that we're about to get into. I'm going to blip it a little. Oh, see, I blipped too much.
That's all right.
And I am in receipt of your note All right, Mr. Foreman, I am in receipt of your note. Judge Canoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt.
Charge it.
Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral.
But charges could be relating to the lesser included within the manslaughter itself. I mean, I said it during the live when you and I weren't really debating, but like make the jury, the verdict slips as simple as possible.
I'm going to repeat for everybody out there and for right now, all 300 and some of you, the jury sheet on count 1 was clear as day. Guilty, not guilty. The jury sheet on count 3, simple, clear as day. Guilty, not guilty. The only place that we have room for confusion is on count 2 with the 3 lesser included offenses.
Unless they actually came back 12-0, not guilty on count 1.
And just then that would, I guess, be an instruction issue that they didn't understand.
Correct. Well, I mean, same diff. I mean, you're relying on the instructions to guide them through the verdict slip. So either way, I mean, like there was if it turns out, and we're going to get to it, if they're even going to get to ask the question, which I think you and I are a little bit pessimistic about their chances of being able to get them in there. But, I mean, if they ask them and they come back and they say, yeah, we were not guilty, well, why didn't you fill out the slip? Why did you just check not guilty and then move on to the second count? I mean, if that's the case, there was something that was not understood.
Right.
So what it is, I have no idea. And I don't know.
Convictions. To continue to deliver our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case.
Nothing.
I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court, please.
But it's not.
And it's true. And Jackson will allude to it in his motion that she didn't ask for any comment from either side. She just goes ahead and, I mean, I think that's standard protocol, like make a record if there's something you want to make a record about.
Yeah, but we've seen Yannetti and
they have
Jackson
no problem making a record.
Speaking up, right? Yep. And they've got all the time in the world right now. They didn't have it then. They didn't have it before. And again, I think that says something. That goes for something. Well, they dismissed right away. She excused them. Maybe that's something to hang your hat on. But right now, when they're just sitting there talking about scheduling, they could have very well said, Your Honor, I didn't want to say anything in front of the jury, to respect and not add any pressure, but I really do think you've got to bring them back in and at least inquire as to which of the 3 counts they were hung on.
Yeah,
or
freedom
confirm
ring.
whether or not they were hung on all 3.
Right. Well, I mean, it's a simple question.
That's what we're saying, freedom ring, is that,
right,
that we're concerned.
And we'll get into it because, do you want to just jump into the motion?
Yeah, I just want everyone to see how she didn't just get off the bench and leave.
Yeah. No, she declared a mistrial and then she left.
No. Then they talk.
Oh, they do?
Yeah, that's my point. She doesn't raise it, but
thank you. Be seated. Court still in session.
All right. I'd like to pick a status date to find out what our next move is.
Do any of them look like they're jumping up?
Sometime maybe the end of July.
texting, "Oh, we got a mistrial."
No one's trying to
I
object.
understand people have
No one's
vacation
Big win.
schedules.
Big win.
asking. Right. So, and then they
Can
obviously
we come in
continue
the
to
week
talk
of the
for a little. So I
21st?
think you can. I just wanted everyone to kind of
That's fine.
refresh their
Poor Mr.
recollection.
Keefe. Yeah, and for the record, people that were wondering, like Jay is beyond done with Karen Reed.
Yeah, he can't take it.
He
It's too
doesn't.
emotional.
He
He doesn't
doesn't
want
want to
to
deal with it.
toxicity of it.
Yeah, it's
None of it.
it's a lot. It's like only because Allie and I have eaten shit for the last 23 years being criminal defense attorneys do we have thick enough skin to handle it. But yeah, Jay's done with it. But we are 100% streaming, live streaming the Alec Baldwin trial together. So, like, I know people were concerned, so that's definitely happening.
And so Maya, that's why we just played that, is just to show, correct. She did not give them an opportunity beforehand, because from what we're about to read, Bob's going to read the whole motion. And I think the affidavits say most of the same things, but and the affidavits. But what we are putting forward here is that after she excused the jury, they could have spoken up and they could have at least made a record. And I just think there's a potential there that it could be considered waived, but I also recognize that they could argue, as they're doing, that they weren't given an opportunity to say anything, and that is one of the considerations the Massachusetts courts, I've been looking at the law, consider when they decide whether the judge abused their discretion in declaring a mistrial. But remember, typically this comes up in the form of somebody's getting like retried, or there's a and then the or they're retried and the judge is
All right, hold on. Nothing happened to Jay. Jay is fine. We are streaming Bald. Jay was sick of Reed. He was sick of how people were acting with it. He was sick of reading about it on Twitter because everyone's so toxic and hateful.
and as far as
coming
this morning,
after people coming after the O'Keefe family is disgusting. I don't care. I don't care what side, like why anybody is ever attacking the family of the victim in this case.
and I think we've explained our position that people have to take into mind, like, family members accept what they're being told by the people that they're supposed to trust.
And they're a cop family. So they're doubly going to believe what the cops are telling them. Every single victim family is told by law enforcement and the prosecutor, trust us. We got this right. So that's what people believe. So, like that is what really set Jay off, is like when he just started seeing all the when Paul did the two things on the two interviews, and people started attacking him. I mean, the guy's brother's dead. Like, seriously, have
Right.
some couth.
But and just to circle back, Jay also changed his platform. He's not on StreamYard anymore, so it doesn't allow for co-hosting. But Bob and Jay, we all talked about it today. They're gonna do the trial. It'll
Yeah,
kind of just be
I'll
different. It won't be a co-hosting situation.
Well, no, it still is. I'm gonna be a guest when he's done
Right.
but
right.
like he's just not you. Like, I won't have the tools, the fun tools.
Mhm.
I won't be able to do the sound bites but yeah, we're gonna alternate. And I think the way the schedule is going is we're handling openings on our channel, and then Jay's gonna cover Thursday and Friday because Allie and I are traveling to the True Crime Podcast Festival Thursday night. We will be there Friday, Saturday, Sunday. If you're in Denver or around Denver, you like true crime, come check it out. It's going to be great. If you do, use Defense 15. You get 15% off your ticket price if it's a last minute pivot and you decide to come hang with Allie and I for the weekend.
Right. And we don't think it would have been an opportunity to poll the jury like Maya, you may be used to. I see you're an attorney, after they come back with a verdict and you poll them, but the judge could have inquired, even by way of note, send them, I need you to go back to the jury room and send us a note as to whether or not you were hung on everything. And if they didn't want to do it right out in front of everybody, whatever the case may be. But that's why we just kind of went through that first part to show they didn't give an opportunity in the beginning, and then she dismissed them, but they could have stood up and said something there at the end.
So Natalie, I get it, but why didn't the defense object to all the stare downs that Paul O'Keefe did to Karen Reed? I'm not sure why the emotional family is allowed to be right in the face of the jury, but Karen Reed supporters are not. Yeah,
I mean,
that I can't answer. It was a very small courtroom, and I know that Karen's family was behind her. That might have been by the request of the defense. You would have thought if they had their druthers that they would have put Karen's family in eye shot as opposed to behind her,
or at least alternated who was.
But we're going to get into some of that because
jury.
even though Jackson misstates which person it was, I mean, I think he was referring to Brian Albert, not Brian Higgins. But when we get into the motion, he's going to discuss this, that allegedly one of the jurors stated that all of the well, I don't want to spoil it.
You'll read it. You'll read it.
All right.
Pull up the one Dizzy emailed you, not the one I did.
Why?
Because it's got Dizzy Mark on it, and
it's got Dizzy marks.
And it's a file stamped version. It came to info though, I think. You know what? I'll just send it to you.
Yeah, I don't know if she sent it to me because
I might have sent it.
I got one from you.
Yeah, is it after 4:33?
It was 4:52. It was a Genius scan.
Yeah, see if it's got Dizzy's mark on it.
Okay.
If it's file stamped, it's the right one.
Yeah, it's Dizzy's.
Okay.
All right, so I'll pull it up.
Thanks, Dizzy.
Thanks, Diz. And let me see. So I'm going to stop this guy and pull this dude up. Okay. All right. Let's make it bigger. Okay, so this was filed this morning, July 8th. And it is Karen Reed's motion to dismiss. All right, so let's dig into
it. Before we get started, I just want to note, because there'll be so many things in my mind once we're done reading this that I want to talk about.
Mm-hmm.
I think it's oversight that they did not ask in the alternative that the judge decide. Because remember, for those of you who were with us during the trial and the verdict, we discussed a lot about like the acquittal first and the soft transition. But we also discussed that in Massachusetts, they find that the judge can decide after a hung jury that there's insufficient evidence, and that for that reason alone, it should be dismissed, or they should be barred from retrying her on that count. And if it were me, I would have, unless that could be a separate motion, and maybe it can be, and maybe it rightfully should be, as long as they kind of do this next. But I'm not sure if it should have been an alternative, but to just ask the judge to find, in the alternative that there was insufficient evidence to allow retrial on count one, the murder in the second. So sorry, go ahead, babe.
No problem. All right, hold on. I'm letting can you guys throw up Dizzy and Tracy's Discord link for Seeking Justice up so people Jay and I tell you this all the time, and Allie does too. If you want the docs from any of the cases, Seeking Justice, which is Dizzy and Tracy's baby, it's their Discord channel or server. It's got everything from every trial that we're following for sure, and
more than
and like Dizzy is super quick getting stuff.
Yeah. Amazing.
It's like I'll hear about a filing and I'll be like, "Hey, Diz, you have this?" And she's like, "Oh my God, I don't have it yet." And it's like 30 seconds after it came out. I'm like, "You're good." I know you'll get it in short order. All right. So here's the motion. Now comes defendant Karen Reed by and through undersigned counsel and hereby moves this honorable court pursuant to, God damn it. I did the, hold on. Sorry. I know I put page display scrolling, enable scrolling. So it's such a joy to scroll as opposed to the pursuant to the 5th, 6th, and 14th Amendments to the U.S. Constitution, Article 12, of the Massachusetts Declaration of Rights to dismiss counts 1 and 3 currently pending against her on the grounds that the jury reached a unanimous decision to acquit her on those charges, and alternatively, because there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Mrs. Reed was not guilty, and that therefore a retrial on such counts would violate the double jeopardy protections of both federal and state constitutions. So then they dig in some case law here. The ancient right to a jury trial is no more, quote, procedural formality, but rather a fundamental reservation of power to the American people, end quote. Erlinger v. U.S. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth, Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretend offenses and arbitrary convictions. Quoting the Federalist Papers, wow, they're really going back. Or maybe that's just the Federalist. Like they're digging through, like, wow, they were digging deep. Prominent among the reasons colonists, I mean, they're going way back. They're going way back to the colonies. Prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact that Parliament and the Crown had deprived them, in many cases, of the benefits of trial by jury. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. Nice little John Adams quote there. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. Quote, the double jeopardy clause provides that no person shall, quote, be subject to the same offense or be subject for the same offense to be twice put in jeopardy of life and limb. And that's Bluford versus Arkansas, which I pulled up. I actually want to kind of dig into that case a bit because it's kind of the seminal case.
I read the entire case.
So did I.
Oh, I thought you said I want to. Sorry.
Well, I want to pull it up for us if we're going to talk about it. I have it up.
I've got it up too.
So do I. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. And they cited a couple of mass cases there. Here, so this is the way you want to see a motion typically set up, where they'll give you kind of the preamble in the beginning, telling you what they're here for, and then they're going to cite some law that stands for the propositions that they're going to be discussing, and then they're giving you the application of what happened at the case at the bar. So here, the very day after a mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors, indicating that in no uncertain terms that the jury had affirmed 12-0 agreement that Miss Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree. Given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Miss Reed on counts 1 and 3 and mandates dismissal of those charges. Alternatively, to the extent that the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue and that the court authorize the defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges against her prior to indicating to the court they could not reach a verdict on the third charge alone, which on its face sounds like a very, very fair ask, right? Problem is, we're dealing with the law, and in the law, there's rules, and in the law, there's such things as waivers. So, you know, like Allie, I know you were digging into a couple things, obviously, but the concept of this post verdict inquiry, because remember, the jury's been released. Now, we did see, and I brought it up to Allie, and we were both like, oh, we were thinking the same thing. We were talking about the Becky Hill situation with the clerk in the Murdoch case and her potentially tampering with the jury. It's a different issue. You know, it's a collateral issue. What did you find anything before we dig in? Or did you have any luck digging into like what are the avenues for them being able to call the jury back in to basically discuss?
I'm telling you, I think this has a situation. I mean, I didn't check all states, so maybe it's arisen before. I have never seen it. I've never heard another lawyer tell me that they've seen it. I've never seen something like this where specifically the jurors are saying, we came to a decision, but then we forgot to tell you about the decision. So typically, you are not allowed to bring the jurors back in to sort of challenge the verdict, right? But this is not technically the verdict, and it's a little bit different. Where you see, and I definitely saw case law about post-trial voir dires, post-verdict voir dire of the jury, but all those situations, and the ones that I'm familiar with as well, is when you've got a guilty verdict and you're trying to determine, were they influenced? Was there outside information brought into the jury room? Were they pressured? Did some sort of misconduct happen in the jury? So all those principles that allow them to do that should technically allow this as well. It's like it's very hard to wrap my mind around, because it's like, did they really? Because they didn't fill out the form, you know? And I guess the argument really needs to be that they were instructed to, you know, that they didn't understand the instructions, and that the judge should have inquired as to, you know, what they're hung on. But in all of the times, even before, like when they asked for um the Tui Rodriguez instruction, they didn't mention it. And we did talk about this on our lives. We talked about the fact that if, because it seems that they hadn't come back with a verdict on count one, it seemed less important at the time where we were discussing it. We were, again, that's that whole acquittal first, soft transition jurisdiction where Massachusetts rejected the acquittal first, that they have to acquit before they move on to the lesser includeds. And so I just lost my train of thought of what I was saying. So if, you know, so we were saying on our lives, I remember, you know, if they had some indication that they had come to a verdict on count one, you know, then it seems like really important that that somebody should raise, well, we should find out if they are hung on count two and let them know to move on to the lesser includeds on that count. But in that time, I'm thinking, well, if the defense assumes that they're not, they haven't even reached a verdict on the murder charge, and they ask them to do that, they're risking the voluntary manslaughter charge coming back, and that's, you know, that's 20 years, you know, or getting a verdict for involuntary manslaughter where it's might be better to just be, you know, just be hung. And I don't know if some of that played into it. But a long answer to your original question was, I think I think it's possible. This is a very unusual situation. Typically, you are not supposed to be challenging the jury's verdict afterwards, and it's more only issues of, were they, did they get some sort of undue influence, you know. But I think that, I think it should be allowed. I think that the judge should allow it. You bring them back, you do it. Probably what would make the most sense would be, you know, every juror independently, and um maybe just the judge and a court reporter. I don't know how any of that looks, but they also ask, and I guess I'll wait till you get to those parts before I kind of spout off about the other things they're looking for here.
Yeah, and I fully anticipate, to be honest with you, in this case, much like in Murdoch, where and Jay and I and you all talked about it quite a bit. Like I just don't believe that the jury wasn't accessing, even if by happenstance or mistake, accessing information about this case while it was going on. And I just have a sneaking suspicion in this case in particular, we're going to start hearing about it.
But again, that doesn't matter because there was no verdict. Like, you only want to get into that stuff if you're the defense, if they came back guilty. Then you want to start challenging whether they had improper influences in there and what went down. This is a different situation, challenging a mistrial after the fact.
No, I know. But like, nonetheless, even if there's no verdict, in light of the fact that, because I don't think they can try it there again. You know what I'm saying? It's like, like in order to, like when I'm filing the motion for a change of venue to where, I don't know, like, I don't know in what area of the state you're going to be able to find a impartial jury that hasn't heard about this case at this point.
Right.
But,
right. And you might want to, I guess you kind of risk this judge ruling on this, but I don't think we'd get a new judge anyway. So this has to happen quickly. So,
yeah. All right. So background: on June 9th, 2022, Miss Reed was charged via 3 separate indictments with murder in violation of MGL Chapter 265, Section 1, Count 1, vehicular manslaughter in violation of MGL. And then cites the chapter count 2, and leaving the scene of personal injury or death in violation of MGL Chapter 90 gives a section. A jury trial began on April 16, 2024. On June 25, 2024, the jury began deliberations. On July 1, when the jury presented a note to the court, all counsel were ordered to the courtroom. See Alan Jackson affidavit, paragraph 7. The note was not presented to counsel for review. See id. Rather, the court indicated that the jury was in an impasse. See id. Once the jury was seated, the court then read the jury note verbatim in open court. And without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. See id 8, paragraph 8. Id means he's referring to the thing that he cited above, which is his affidavit. In case you were wondering what id meant. In short, neither defense counsel nor the defendant consented to the mistrial. Footnote 1 is, while the jurors' note, as read by this honorable court, indicated the impasse was on charges, it did not say whether the charges were those within count 2, i.e. the multiple ways to find guilt on count 2, or extended to other counts. The affidavits attached herein indicate the former, not the latter. At least for 3 of the jurors. The problem
really it's 1 and 2 intermediaries.
Yeah, right. Exactly.
They don't count.
They don't count. Like, at this point, there's 1 juror that they've heard from.
Right. And that's at least they have that. They didn't have that, they'd be screwed. It was all just intermediaries.
Yeah. That's some like telephone game. Oh, yeah. You know what I heard
on Twitter?
You know what I heard on Twitter from this dude? Yeah. That's not going to do it in a court of law. Let me just start this last sentence again. In short, neither defense counsel nor the defendant consented to the mistrial, and the court never ascertained from the jury whether its deadlock was in relation to 1, 2, or all of the charges in the indictment. And that is on Judge Bev. She absolutely, yes, defense counsel, absolutely. I think they were basking in the glory of the mistrial, and they shot a big blank there. You know who wouldn't have forgot that?
You know what? Even the best forget things because it's all happening so quick. I've definitely been there where I've been like, oh my Lord, I should have said
There's no way. There's no way you would have forgotten that. Like, we would have been talking about it. We would have been like, dude.
We would have been, right. We would have been discussing ahead of time. We would have had a game plan for if it happened.
Well, we would have said, Judge, could you at least ask what they're deadlocked on? So you're deadlocked on all 3 counts. Let's just be clear about that. We don't need to count. We don't need to know what the split is. but you're deadlocked on all three counts. Because then if they come back, well, no, we got to not guilty on, the
Count 1 and 3.
Yeah, the murder too. I'm like, but okay, all right, well then go back, fill that form out because you got a unanimous verdict on that, and then if you're still stuck on count 2, like that conversation should have, because that's what I'm saying. Like just in just trying to be just and fair in terms of what the jury actually, what their actual purpose was in terms of and their actual, if they are spoken to and they said, yes, we all came to a decision on the second degree murder, then that should stand, but when we get to the case in terms of it's, I don't know, we'll read through it. I don't think it's a powerful argument by the defense here in this motion, to be honest with you. I'm disappointed in how it went down, but I don't know. But let's keep going. So the following day, on July 2nd, Attorney Jackson was contacted by a juror in this matter, Juror A, who stated that he or she wished to inform him of the true results of the jury deliberations. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty on count 1, second-degree murder. Juror A was empathetic that count 2, second-degree murder, or count 1 was off the table, and that all 12 of the jurors were in agreement.
Not empathetic.
Oh, emphatic. Sorry. That count. Some of my.
It's small, yeah.
No. But some of my shit's cut off. Are you seeing that? Like the count 1 thing's gone. Second degree murder was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. It at 5. The jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury or death. It at 6. Another day later, on July 3rd, 2024, Attorney Yannetti was contacted by 2 different individuals, hereinafter informant B and hereinafter informant C, who had received information from 2 distinct jurors, hereinafter Juror B and Juror C.
So that's how you get 3 jurors.
Right, which he didn't talk to the jurors.
Right.
Like it's not the same thing as talking to the jurors. This could be I don't know who these informants are.
Right. I mean, it's something, but thankfully they've got the
I mean, I think the question is if like I'm asking informant B and informant C, hey, why don't you just see if they'd be willing to talk to me?
That might be you soliciting them to talk to you. That might broach the line.
Maybe. I don't know.
They want to walk the finest of lines with jurors.
For sure. All right. So who had received information from 2 distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case? Yannetti Zaffe, paragraph 2. Informant B sent Attorney Yannetti a screenshot he or she had received from someone, hereinafter intermediary B, of text messages that
informant B got it from intermediary B.
It's a straight up telephone game. It's of text messages that intermediary B had received from Juror B.
Oh Lord!
That screenshot, Juror B texted that the following to intermediary B. Quote, "It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose." Sick. All right. Now, I saw people talking about how, like, Jackson, like, that wasn't Jackson's.
Right. That's the
typo.
way the person texted.
So when there's something improper that was texted to you, you put that little sick there. I don't remember that being there. Maybe it is with the Higgins Albert thing. That's how you indicate that there's a typo or some, it's a misstatement. So informant C had been in contact with another individual, quote, intermediary C, who is a coworker and a friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent Attorney Yannetti the below screenshots of his or her text messages with intermediary C regarding what Juror C revealed in the Zoom meeting. So intermediary C, quote, "No consideration for murder 2. Manslaughter started polling at 6-6, then ended deadlock at 4-8, 4 no, 8 yes. So, I mean, does that mean that they went in and did a straw poll even though she asked them not to?
No, that just means that their first poll, that it was 6-6. I don't think it means a straw poll.
Okay. Informant C, quote, interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges, sick? Because that's supposed to say charges, not chargers. Go back to the jury verdict slip that was all confusing. Intermediary C, quote, she should have been acquitted. I agree. Yes, the remaining charges were what they were hung on, and the instruction paper was very, very confusing. So it at 10. Argument. The jury's unanimous conclusion that Miss Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes reprosecution. So, quote, what constitutes an acquittal is not to be controlled by the form of the action in question, Taylor, which is a mass case at 482, which is quoting Martinez versus Illinois, which is a federal case. Rather, the court must determine whether the action actually represents a resolution, correct or not, or some or all the factual elements of the offenses, the offense charged, Commonwealth v. VAB. The mere presence or absence of check marks on a form is not dispositive. Okay, here the attached affidavits by Yannetti and Jackson reflect statements by 3 deliberating jurors that the jury had reached a final unanimous conclusion that Miss Reed was not guilty on counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the results of the jury deliberation. See Jackson affidavit paragraph 5, quote, juror A was emphatic that count 1, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. Yannetti's affidavit, paragraph 4, reflecting text message from juror B, it was not guilty. It was not guilty on second degree. No one thought she hit him on purpose or even thought she hit him on purpose. Did you ever figure out what that meant? I still never figured out that. It's like the same. It's weird. Okay, reflecting on juror C's statement relayed by intermediary C that there was no consideration for murder 2 and that Miss Reed should have been acquitted on that count. To hold that this firm conclusion did not amount to an acquittal simply because it was not recorded in a verdict form would be to elevate form over substance in a matter prohibited by the foregoing United States Supreme Court and Supreme Judicial Court precedents. So this is where it gets sticky for me. Now, both of us have read Bluford.
There's some differences in Arizona law than here that speaks directly to that whole
Arkansas
acquittal first.
Right. And the judge had asked. There's difference. The judge inquired as to, because of the acquittal first aspect of it, whether or not, they had agreed unanimously on the capital and then the first degree before they got hung up on the manslaughter.
And that, I think there, if I'm remembering correctly, it was one charge and then those were all the lessers. Where here you've got 3 separate charges, one of which has lessers.
Yeah. Okay, the Supreme Court's decision in Bluford is not to the contrary. So they're anticipating when the Commonwealth comes back at them, they're going to say, hey, here's Bluford, take it and shove it up your ass, because it's pretty clear about what it says. So they're doing a little anticipatory argument here. There, a juror had reported during deliberations that the jury was unanimous against the charges of capital murder and first-degree murder, but split on the manslaughter. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, court declared a mistrial. Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited re-prosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the juror's report. Quote, the jury's deliberations had not yet concluded, and it went back to the jury room to deliberate further. It at 6:06. Here, by contrast, the jurors' statements reflect a final determination that Is that persisted? I can't make out.
Yeah.
Persisted through the end of the deliberations. Even assuming arguendo, and contrary to the foregoing, this court finds that retrial would not be prohibited under Bluford. This court can and should afford broader protection under Massachusetts state law. See Commonwealth v. Tinsley, a 2021 case where, quote, unlike the U.S. Constitution, the Massachusetts Declaration of Rights does not include a double jeopardy clause, but our statutory and common law have long embraced the same principles and protections.
This is where they could have added that whole acquittal first argument, that Massachusetts has specifically rejected acquittal, the acquittal first method, and we allow for partial verdicts, and that all of that should have been. I was almost like thinking,
did you explain acquittal first?
Well, I did before, and I guess I will again. So it's just that Massachusetts has specifically rejected that they are an acquittal first jurisdiction, meaning that they have to acquit on the larger offense on the offense charge before going on to the lesser included. And they said that the jurors in Massachusetts can do it like in any order, in any way. Now, bear in mind, they also note that it is fine pre-deliberation for the jury instructions to lay it out as though, which Bev did here, you must first find him not guilty on, now we're talking about count 2, on the charged offense of manslaughter, and then move on to the lesser included and continue. What words did she use? Down or in descending order. And that each time they had to first find not guilty before they went down. And the court recognized that's fine instruction pre-deliberation. But then once the hung issue arises, that's the jurors should be told that they can, if they have either found not guilty on the offense or are unable to reach a decision on that, to move on to the lesser included.
Right. So argument B, reprosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was unanimously agreed. So, quote, the double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal, quoting Taylor. Thus, this is another quote, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. Here, Ms. Reed did not consent to the declaration of the mistrial. See Alan Jackson's affidavit, rejecting argument the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed.
So there you have it.
Right. Yeah, I mean, I blame Judge Bev first and foremost, but I'm worried these dudes waive this.
Well, I'd have to read that. I didn't get to that Edwards case, so I'd have to read that to see how they decided that. But that's helpful law for them.
Well, yeah, like
by not
when I brought
objecting.
that up to you, you're like, wait, what? Object to a mistrial? like, you know what I mean? Like, because I was saying, like, she didn't ask for any kind of comment from either side. She just went right into it. You know,
and that's probably what this sort of relied on is that they weren't asked.
Well, I don't think she's asking if it's okay, but I mean, she certainly should have inquired as to whether or not they had a statement or wanted to get something on the record before,
like she did for each of the other times it came in.
Exactly. Or right when they were deadlocked, before, like, what's your argument on due deliberations? Like, I want to hear them, because I have to rule that there's been due deliberations before I give the Toohey Rodriguez charge. So both sides got to have their say.
Right.
So absent the defendants, like Lally probably wanted to know too. I mean, like, I think everybody wanted to know.
You can guarantee if one of the jurors is in disagreement with this position, they're going to call the the
100%
prosecution.
guaranteed. Absent, like, which is what gives this weight, because the juror who would have said this would have to know that the defense is going to run and file a motion based on this, and that, you know, they're going to be put on blast as the person, you know, without naming them in particular, but, you know, and they have to know, if they're full of shit, that whatever juror was not unanimous on count one is going to be like, I don't
Well,
know what
or
this
if
guy's
it's
talking about.
something more like, well, we said that, but we didn't finalize it, or we would have signed the thing. Like, we talked about not signing it on purpose or something, you know, like whatever the case may be.
It's sticky.
Yeah.
It's sticky. It's sticky. I mean, I fully anticipate that the state's gonna now. I mean, it's the same thing. They can't call and try to talk to the jurors.
No.
Jurors basically have to reach out to them, you know.
Yeah.
So it's like, absent the defendant's consent, quote, the state and federal double jeopardy protections bar, as a general rule, retrial of a defendant whose initial trial ends without a conviction. Ray v. Commonwealth. This rule is rooted in the importance to the defendant of being able, once and for all, to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate. Cruz v. Commonwealth. Accordingly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. That's Washington. Before a court declares a mistrial for manifest necessity, one, counsel must have been given a full opportunity to be heard, and two, the trial judge must have given careful consideration to alternatives to a mistrial. I mean, here, when they're deadlocked, that's what it is. Like, you know, I mean, she gave the charge.
Right, but she could have inquired as to which, and they make that in their next paragraph, that they make the point.
Here, the defense respectfully submits that the lack of opportunity to be heard is alone dispositive. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. See Jackson Affey, paragraph 5. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Citing Commonwealth v. Horrigan, finding no manifest necessity where no opportunity was given counsel to argue the propriety of the question or the necessity of a mistrial. Commonwealth v. Stewart. Finding no manifest necessity where the trial judge first ruled that he was going to declare a mistrial, and then, almost as an afterthought, unenthusiastically asked whether counsel objected. Do you object? Okay. The record is independently lacking on the second prong, as it reflects no careful consideration of alternatives to a mistrial. Again, citing Ray, here, there was one obvious alternative: to simply ask the jury to specify the charges on which it had deadlocked. Had the court done so, and had the jury articulated its verdict consistent with the statements of jurors A, B, and C, the double jeopardy implications would have been clear and decisive. Indeed, with virtual unanimity, the cases have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict. And then when the jury hands down a partial verdict, the judgment is rendered on the counts upon which the jury has reached the agreement. So the Supreme Judicial Court's holding in Commonwealth v. Roth. Roth.
Sorry.
The court should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. As the Roth court acknowledged, inquiry concerning partial verdicts on lesser included offenses, and this is italicized for emphasis, that have not been separately charged, carries a significant potential for coercion. And see also Bluford, the Supreme Court case. So, declining to require the court to consider giving the jury new options for a verdict in the form of partial verdicts on lesser included offenses were, quote, under Arkansas law, the jury's options were limited to two: either convict on one of the offenses or acquit on all. Such inquiry, in effect, implies the jury should consider conviction on the lesser count. No similar danger is present, whereas here, the jury was asked to return 3 separate verdicts on 3 separate counts.
Correct.
See Roth.
Again, this is where they should have put in the stuff, and maybe they do because I don't think I read the last part because I was researching, but that Massachusetts specifically has rejected the acquittal first method.
Yeah. Distinguishing situation, quote, where a defendant has been charged in a separate indictment or complaint, each with separate verdict slips. In this circumstance, where the jury reports a deadlock without specifying the counts on which it has reached an impasse, it is a straightforward, and the defense contends, constitutionally required follow-up to ask whether the deadlock relates to some as opposed to all counts. Indeed, the Supreme Judicial Court has explicitly stated where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts, despite deadlocked on the other counts. And that's a Juvenile v. Commonwealth, a 1984 case. And then C, alternatively, the defense is at least entitled to conduct post-verdict inquiry. So underside counsel did not initiate the communication. There you go, babe. Being super careful. We didn't call them. They called us and the intermediaries. The intermediaries.
And I'm sure that is what happened.
Yeah, I'm sure.
Yeah.
Undersigned counsel did not initiate the communication with jurors A, B, and C. It's a kind of a disingenuous statement. You didn't talk to B and C. You talked to intermediaries who talked to.
And you talked to informants who
Yeah,
talked to intermediaries who talked to
the
jurors.
Which resulted in the disclosure of information that is memorialized in counsel's affidavit that are appended to this motion. Should this court find that further factual development is required, the defense respectfully requests that the court conduct a voir dire of the jury and or evidentiary hearing to substantiate the existence of an acquittal. Should the court, and that's footnote 2, or I don't know where it is. Is that up here?
No, it's at the bottom of 9.
Oh, it is?
Massachusetts.
No, but like I didn't see where the footnote itself was. So Mass law, to the contrary, clearly permitted the jury to return a partial verdict on some, but not all counts. Should the court seek an affidavit of each juror, the defendant asks for the court to authorize underside counsel to initiate contact for the sole purpose of asking each juror whether the jury had unanimously agreed the defendant was not guilty of counts 1 and 3. The Supreme Judicial Court has held that because of the importance of the issue, juror bias is a legitimate subject for post-verdict inquiry. So Commonwealth v. McCallop. It is similarly a fundamental tenet of our system of justice. The defendant may not be retried for a crime on which she was previously acquitted by a jury, and the defense submits that post-verdict inquiry is equally warranted in the present context. So just as the court in McCallop approved questions as to the existence of racial bias, questions about a matter more attenuated from the content of the deliberations, whether the jury had unanimously concluded that Ms. Reed was not guilty of counts 1 and 3, do not invade the heartland of jury deliberations, but preserve the defendant's precious rights to the favorable outcome of a jury trial and to the protections of the double jeopardy clause as it's related to state judicial protections. Conclusions for the foregoing reasons, Ms. Reed respectfully requested this honorable court issue an order dismissing counts 1 and 3. All right.
And then let me just bring up, well, they cited this rule because I think it's helpful.
I'm going to bring up the affidavits too.
Oh, okay, yeah.
I have them.
In the one I sent you, they're attached. She sent them.
Yes, I know.
But Dizzy sent them as well.
Oh, but they're not attached.
They're like in separate attachments. But the one I sent you earlier today had them.
Yeah, that's the one I had up ready to go.
Okay, then they're there.
We wanted to use Diz's.
Right. I think you're fine for the affidavits.
Yeah. All right. So I'm going to pull them up. Just knock them out. You know what I mean?
And then I've got Rule 27 after that.
Ooh, good old Rule 27. All right, so this is the AFI of David Unetti in support of defendant's motion to dismiss. A little bigger for y'all. I, David Unetti, do hereby depose and state that the following is true to the best of my knowledge and belief. I'm a licensed attorney in Massachusetts since December 20th, 1989. My office address is 44 School Street, blah, 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 blah. I was retained to represent the defendant, Karen Reed, regarding the above captioned matter. On July 3rd, 2024, I received communications from two different individuals, hereinafter informant B and informant C, who had received information from two distinct jurors. Wait a second. That's different than what the motion said. Where's the intermediaries?
Say it again.
Or is it, okay,
I
so
received communication from two different individuals, informant.
who had received information from two distinct jurors. I thought, where are the intermediaries? Well, I guess they're down here. Both of whom were part of the deliberating jury in the case. To my knowledge, informant B and informant C do not know each other. On July 3rd, informant B sent me screenshots that she had received from someone hereinafter, there's good old intermediary B, of text messages and that intermediary B had received from juror B. In that screenshot, juror B texted the following to intermediary B. It was not guilty on the second degree and split in half for the second charge. When the judge sent us back with that Hernandez sick thing to look at the other side, the Hernandez charge. So that Hernandez thing to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. They gave us free counseling forms when we left, in case they have PTSD. Based upon the first names of juror B given to me by informant B, I believe I am able to positively identify which juror he or she was and confirm that she or he was a deliberating juror. On July 3rd of 2024, informant C contacted me to say that he or she personally knows juror C as they used to work together. Informant C and juror C also have a mutual friend, hereinafter intermediary C, who is a current coworker and a friend of juror C. Informant C told me that he or she had posted something about Karen Reed on Facebook on Monday, July 1st, 2024. She told me that she believes the post led intermediary C to text him or her and inform her that jury C was a deliberating juror on the case. Informant C told me that she thereafter reached out to juror C via text message and discussed his or her experience as a juror in very general terms. They discussed what an exhausting experience it was and that juror C was relieved that it was finally over. Intermediary C told informant C that juror C would be participating in a Zoom meeting with a number of friends to discuss what happened with the trial. Today, informant C sent me three screenshots of text messages exchanged that he or she had with intermediary C. Informant C told me that intermediary C was reporting to him or her during this exchange what juror C had revealed during the Zoom meeting. The text message exchange reads as follows. Intermediary C, quote, no consideration for murder 2. Manslaughter started pulling at 6-6, then ended at deadlock at 4 no, 8 yes. He or she was very consistent in the fact that they could only consider things that were admitted into evidence. Ultimately, he or she voted no because of the cause of death was twofold of hypothermia and head injury, of which he or she was convinced that the vehicle did not cause both. What? How the hell is the vehicle causing hypothermia? I don't even get it. The whole jury felt very intimidated by Higgins' sick. Oh, they did put sick there. Good. Presence at the end. He's obviously talking about Brian Albert. He or she's not sure what she's going to do. He or she's going to lay low for a couple days and see it where it takes him or her. Hasn't rolled anything out. The jurors all have a group text going. I mean, They could still be deliberating right now. I mean, for real. I mean, obviously not in the room, but you don't think these people are continuing to debate via this text?
Oh, yeah. They're
in?
definitely still clearly, they're still talking about it.
Right. I mean, informant C, interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Go back to the jury verdict slip. That was all confusing. Oh, it says goes back to the jury verdict slip. That was all confusing. And this is intermediary C. She should have been acquitted. I agree. Yes, the remaining charges were what they were hung on. And that instruction paper was very confusing. Informant C, what a great experience for him or her. Amazing that they let Alberta in the last day. Is that supposed
Albert.
to be? Yeah, or the Alberts.
Alberts, yeah.
Intermediary C, she felt honored to be a part of it. She was redacted physical description of juror C. Everybody else was from a professional walk of life. They all got along, never heated. They agreed to disagree and respected each other. Doesn't that fly in the face? Didn't somebody say it turned into bullying after?
Yeah, that might have been a different one.
Yeah, but I mean, just goes to show you. I mean, perception's everything. Everybody perceives things differently, individually. Informant C, that's the way it should be. I knew it was an intelligent jury, or I don't know what that's sick.
I think it's I.
Yeah, I knew it was an intelligent jury. They will be studying this case in law programs for years to come. I.e., sick, how to not to investigate and try a case. Well, I mean, they couldn't have tried it that bad if it ultimately ended up with a 4-8 guilty on the manslaughter. If they all agreed on no for murder 2, they should make that clear to the DA and the court. It's basically a case of double jeopardy if she's retried on that charge. Based on the description of juror C given to me by informant C and confirmed by the redacted content of the above text message exchange, I am able to positively identify which juror he or she was and confirm that he or she was a deliberating juror. So that's Yanetti's. And then we got Jackson's. You have any thoughts on that before I jump to the next one?
I mean, I just think that he did, the best that he could, and without disclosing.
Who, Yanetti?
Yeah, I mean, without disclosing who the lawyer, like who the lawyer is. I mean, who the juror is, and so he talked to. He's only got juror.
No, they didn't fill out the slips. They didn't like that. That's the whole issue here. Like, that's what Allie's saying. She's like, and it was. I mean, that first count, simple as pie. Do you find Karen Reed guilty of second-degree murder? Guilty? Not guilty? There's 2 places to check. So it's befuddling to me. Like that's what I'm saying, and that's what Allie was saying earlier. It has to relate back to the instructions themselves, because the instructions were very lengthy. Especially when it got into, I guarantee you it all relates to count 2. And
then they got the supplemental instruction, but only to count 2. So
right. But what I'm saying is, I think that count 2 is infesting everything else with its mass confusion. It's a confusing verdict slip, and the, do Bob and Allie know about Proctor? About what? That he got?
Yeah, we'll get to that. Suspended without pay.
Oh, yeah. Good.
And so I don't forget, Karen Reed got a new lawyer to argue this. So we'll talk about that after we get through this.
Okay, so Ajax, it's his Affy. He's a partner at the Los Angeles firm of Worksman, Jackson and Quinn, LLP. He's been licensed to practice since 1994. I am counsel for Karen Reed, appearing on her behalf in the Commonwealth of Mass, pro hoc vice. And pro hoc vice is when you are not licensed in the state and you make a request to the court to be able to try a particular matter
for this one time.
On Tuesday, July 2nd, 2024, I was contacted by Juror A, true name and identity withheld to maintain anonymity. Based on my conversation with Juror A and that juror's description of who she is, where she was seated, and certain identifying information, name, occupation, disclosed during the voir dire process, I was able to positively identify which juror she was. Juror A told me that she was seeing inaccurate reports about the split among the jurors related to the mistrial that the court declared the day before. Juror A stated that she wished to be respectful of the privacy of the deliberative process, but did wish to inform me of the true results of such process. Juror A indicated that he or she believes it's important to disclose such results because he or she believes that those results significantly impact Ms. Reed's rights. Juror A told me that the result of the deliberations was that the jury unanimously agreed that Karen Reed is not guilty on count 1, second-degree murder. Juror A was emphatic that count 1, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. So, I mean, that sounds like the same juror that...
No, I think they both want to just emphasize that it was emphatic because they need it to
But
be,
they both said off the table.
well, because maybe that's the language that they were using in there.
It's off the table. It's off the table. We're going to table it. We're offing it off the table. I don't know. It could be the same juror, or it could be a different one. They're all using the same language like robots. Juror A told me that shortly following the determination regarding count 1, the juror also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury or death. On July 1, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for the defense counsel to be heard, the court declared a mistrial and excused the jury. Neither Ms. Reed nor her counsel consented to the entry of the mistrial. 10, defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including lesser included offenses, and on which counts or counts the jury may have arrived at a verdict. Nor did the court on its own inquire of the jury foreperson on which counts the jury was at an impasse, and whether the jury could or did reach unanimous agreement on any of the other counts. Had the court so inquired, it appears clear that not guilty verdicts would have been recorded for count 1 and 3. Ms. Reed was denied her right to receive those verdicts in her favor. So, the foregoing is true and correct to the best of my knowledge and belief, and under penalty of perjury under the laws of the United States and the states of California and the Commonwealth of Mass. So that's that.
All right, so let me just pull up while we're here. Oh, I opened it in a different window so that I could do this. All right, hold on. All right.
Yeah, Tracy, thanks for the $5 holla. Yeah, I agree. I'm not a fan. I'm not a fan of Alan Tui Rodriguez dynamite charges, where, depending on the jurisdiction, what you call it. I agree. I think that they it's like forcing people to go against their better judgment. I mean, it's like you're forcing them to try to come to a conclusion. I'm happy that the jury stood firm. That they didn't cave. I mean, people should stand by whatever they believe is right. They shouldn't be forced to come to a verdict because some judge reads some kind of verdict, like a charge. Hey, you have to come up with a decision. Go back there. Do it. Sometimes people just can't agree to shit. Period. And this is one of those cases. I don't know if they'll ever get a verdict on this case.
All right, that's about as big as I can get without cutting it off. But what's important here is B. several offenses or
What are we
defendants.
looking at, babe?
So this is their Rule 27 verdict rule, and it talks about what happens upon a verdict. So A is just the verdict shall be unanimous. It shall be a general verdict returned to the jury by the jury to the judge in open court. And I'm sorry, I'll just read it from here instead of trying to do it like that.
Yeah, just
The
read it.
jury shall file a verdict slip with the clerk. But B, if there are two or more offenses or defendants tried together, the jury may, with the consent of the judge or at any time during its deliberations, return or be required by the judge to return a verdict or verdicts with respect to the defendants or charges as to which a verdict has been, I think that says has been reached. And thereafter, the jury may, in the discretion of the judge, resume deliberations. The judge may declare a mistrial as to any charges upon which, I got to go back and look at it over here because it's cut off a little bit there, and it's my eyes are for shit. Which the jury cannot agree upon a verdict, provided, however, the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct such verdicts be received and recorded. So that's, what the judge may require. And I think, there could be there is at least an argument that they weren't given the opportunity to tell the judge to do that before the judge um dismissed the jury. So there's that. And then I just want to say they hired a new lawyer for this. And he is, let's see, I think I have his name up here. Martin Weinberg. Looks like he does a lot of white collar cases. He's got a big federal practice, and he's also an appeals attorney. And that's when you're getting into the law and you're really trying to, bring something home, somebody who does criminal law plus appeals that's going to be the person that's got like all the inside knowledge about all these things. Like I was almost tempted to email Yannetti and be like, did you know they rejected the acquittal first in Massachusetts specifically? I assume he does. I just think it was pertinent, especially when distinguishing from the Bluford case. But so that's Martin G. Weinberg. He entered a limited appearance just for the purposes of
This.
of arguing the motion to dismiss. Yes.
Right.
So let's answer some questions and then we can get into
So second hook, $5 holla, how vindicating that very thing that Bev got snippy about with them on the verdict form is the entire reason for this mess.
well,
You so's are in order.
well, I will have to say, if they didn't ask, assuming all the confusion was on charge 2, at count 2, had they not asked to change it, where it used to say just not guilty on the charged, oh no, it didn't. Yeah, not guilty. If it just had said not guilty on the charged offense,
Right, and didn't include the lesser
or on the
included
lesser
language.
included,
Yeah.
right? But now that I think about it, that prior, I gotta actually still have them up, the verdict sheet. I think the original second degree verdict slip, it did just say not guilty. So not guilty of the charged offense. So it's basically means the same thing, not guilty of the charged offense or any lesser included. Which they sort of were fine with that at the end of the day. And I don't know that she would have done what they originally asked for, which was it to say not guilty on the charged offense, and then you know specifically just the charged offense.
So Julie had a question. Whose ultimate responsibility is it to determine whether they were at an impasse on all or some charges? It would seem Judge Bev. I mean,
Yes.
it's her courtroom, I mean, Yeah, but when she doesn't do it, I'd expect defense counsel to say, "Hey, Your Honor, would you mind asking them whether it's you're going to call them back in or what have you, or you're going to have them write a note back to us to say, I'm just confirming you are deadlocked on all 3 counts." That's all she had to ask, that one question. And they were like, no, we're good on 2. I'm dying to hear the explanation, because when we read the notes, we were all like, Judge Bev said, I've never seen a note like this in my entire career. This juror's a genius. It's like, yet this thing comes out that, they were unanimously agreed on not guilty on the biggest charge, absolutely the scariest charge that Reed was facing, and it's like a big deal. And if it's, if it turns out that it's true, and the judge, it's clearly going to go up to the appellate court, obviously, and this thing could, just linger. But like, the question I have for you, Allie, is, so if they have a year in which to bring the case again, and what happens if the appeal isn't done by then, if they're still deciding whether or not, or say they get,
Well, that's assuming they can take an interlocutory appeal. I don't know. I'd have to check Massachusetts law when you can take an interlocutory appeal, but I don't know. I don't know whether this would be that. And then I'm just going to circle back to the.
Retry, like potentially, like a potential double jeopardy case, like seems like that would be something that you might be able to get up to an appellate court.
Right. Well, in theory, if they did file that, that would toll the time for the 1 year, unless there's something I'm missing with, Massachusetts law. But as a general rule, anytime the defense does something to stall that, clock, they'd have to waive that by filing the motion. And then I just want to bring, this back up again. Let's see. Okay. So going back to the wait, damn it. Okay. It's not big enough. Hold on.
That's what she said.
Oh
Oof,
Lord.
boy.
Jay's not even here.
I know. Couldn't help it. It was low-hanging fruit.
Yeah, I guess so. I got to go a little smaller. Is it all in there, or do I have room to go bigger?
That's what she said.
Jesus.
For who? For me to read, or for you?
Well, for it to be seen in this window, because
it's going to cut off like a portion of it. Make it a little bit smaller. It's cutting off.
You got it off?
Yeah, there. That's good.
Okay. So under the soft transition rule, and again, that's in Massachusetts, they rejected the acquittal first, meaning they have to acquit before they can move on to the lesser. The jury are instructed to move on to consider lesser included offenses where they did not find the defendant guilty of the greater offense, rather than being required to find the defendant not guilty of the greater offense before moving on to the lesser included offenses. While such instruction will suffice before the jury commences deliberations, so during the instructions, a reasonable efforts instruction should be given where the jury, during deliberations, announce they're deadlocked of the greater offense. And then they go on to say a reasonable instruction informs the jury. So a reasonable instruction is like the Rodriguez, the Tui Rodriguez instruction, that if after all reasonable efforts they reach agreement that the defendant is not guilty of the greater offense, or are unable to agree as to the greater offense, they may consider whether the defendant is guilty of a lesser offense. And this is what I kept kind of screaming about, like, while we were going over this, like, why is this, the whole soft transition instruction and not acquittal first thing not being addressed here. But again, I thought it was maybe that the defense thought it didn't matter because you assume the jury didn't come back with a verdict on count 1. So based on that assumption, you might not want to push the issue if you're the defense and have them come back as, guilty on involuntary manslaughter or or something like that. Um, so go back through all the all the questions. Did Jackson did not misstate it was a juror who confused. Right. We realized that was the intermediary or whoever. Okay, Charlotte, there aren't instructions about what to do if you don't reach a verdict. As far as the jury is concerned, the judge says mistrial and you go home. I mean, that's true, but when she gave the supplemental instructions after she was trying to resolve this whole issue with the second counts verdict sheet, she did specifically tell them you first have to find not guilty on the charge defense of manslaughter before you move down to voluntary manslaughter, involuntary manslaughter, um, and all of those. And that's what we're saying that they must have been um confused about. But you're right, there's not a specific instruction like what you're supposed to do when you don't have a verdict. And that's what this case that I was just pulling up kind of focuses on, saying the judge should give a reasonable efforts instruction that tells them if you're hung on the main charge on count 2, again, move on to the lesser included. Um, so And then Aaron M says they aren't lawyers. I don't think they understood that they could return an incomplete verdict or that it impacted Karen not to raise the issue. Media reporting verdict after prompted them. I absolutely 100% agree. And that's why I agree that the judge should have given that, specific additional instruction, like that if you're hung, move on to the lesser includeds and, let us know which specific counts you're hung on, something to that um, effect. And then Rocky says, if the defense can make the judge a witness to ask about her private conversations with the jury after, no, I don't think that that would be, unless a juror says, we told the judge. We were talking to the judge in that room afterwards. We told the judge that we had a unanimous verdict on. I mean, if that's the case, that's a huge issue. And then, you know, the judge would have to potentially be, unless she were just to agree. I mean, I don't know, but it would definitely definitely raise some issues. Um, and maybe she would have to recuse herself from a second trial only because it shows some sort of lack of
Bias.
diligence or like toward to the
Well, I think that
defendant.
would show straight up bias.
Right,
Like,
that
if
bias, that's
she
what I meant. Sorry,
yeah,
a huge bias to the defendant that she would have that information and
right.
not instruct them like, okay, wait, we need the we need
Wait,
to
well,
get
I'm
this
gonna give
on the
you
record.
back the verdict slip for count 1 and 3. So go ahead and just fill those out because clearly you've reached a unanimous decision on that. So Sheila, it sounds like these folks are talking to each other. At Richard Pluckett, but don't lawyers have the opportunity to see the notes before it's read into open court? I mean, we
Did
don't.
not hear. They did not hear on
I
this
mean,
note.
it's typically the same for us. They typically read it to us. Like, have you ever personally read it?
I think sometimes they, like, hand it to like, I know if it said like, we had one where it said the verdict, the breakdown, the split, so they didn't hand that to us, but I think that we've actually sometimes, yeah, they'll let you see it, sometimes not. Either way, they're reading it out loud
Right.
before they bring the jury in, and the lawyers and the judge are talking about it, and,
And the notes
um
are made, of record. They're on the record. They're part of the record,
like, the actual note gets
the actual
filed.
note itself. So it's not like, Judge Bev can be bullshitting what was on the note. So if
I've
that
never seen a situation like what happened here, where she just says they're at an impasse, brings them out, and then reads the note, like, without, like, typically the note is read, in Illinois, we don't call them out every time a note's read and have the judge say anything. A lot of times they do just send back a note like, "You have everything," which I can't
Right.
remember in the first one if they just sent a note back or if they called them out and said, "You," I think they did. They called them out and she said,
Yeah.
"You have everything. Go to lunch, continue," like
Yeah.
whatever.
I think she did too.
Um,
All right. Joe Schmo. Go ahead and read it, babe.
we got to see that form compared to the standard mass jury trial forms, and the forms were absolutely edited with critical instructions or options omitted. We still haven't seen the actual final second um count 2, which is manslaughter, actual verdict sheet. We know it looks I'm going to bring them all up cuz I have them right here. Um Here we go. So count 1 is very simple for murder. Not guilty, guilty. Not guilty, guilty, sign it. Move on to verdict slip
Wait,
2.
what is the verdict 1 read? What's it? Guilty of
Not guilty
offense?
or guilty of offense as charged, murder in the second degree.
Yeah, I mean, it's pretty straightforward.
Right. So the second one, the second one we know, and she made some other like changes to the layout, which we're not sure, says not guilty of the offense charged or any lesser included offenses. So if they were hung on on three on 3 and 4 of the lesser includeds, she they could not check off not guilty. They've got guilty of the offense charged, guilty of the lesser, guilty of the lesser. So that therein lies the problem. And that was what Jackson was arguing initially. How do they check off on this form not guilty of the offense charge? How do they tell you that, Your Honor? How do they tell you that? And when they came back, he said, "I'm fine if you just change it to say not guilty of the offense charged or any lesser included."
Which I
Um,
think Heavy Metal Rehab's comment here like plays right into that. Perhaps they thought it was an all or nothing type situation, and because they didn't come to a verdict, they didn't fill out the verdict sheet.
yeah,
Yeah,
I
and look, I mean, if it was 12-0 NG on 1 and 3, then yeah, that's exactly what happened. I mean, for some reason they felt precluded from filling out the forms. If in fact they did reach a verdict on those 2 counts,
right,
I mean, there must have been something going on. And again, we've got the foreperson who's writing the notes who clearly seems to understand kind of the mechanics of the law to a certain extent. And it seems like that would have been a question. Like if they were confused on it, that should have been a question. Can we
right.
can we find her not guilty on certain counts, and that doesn't affect our ability to be hung on another one, or anything of that nature?
Right. And then
But
you've got
the fact that we didn't get that note just makes me I'm dubious.
right.
I'm
I'm
dubious on this. I have to say. I have to say.
We'll have to
I
see if
know that.
people start coming forward, saying, "Wait, no, we were sort of like in agreement, but it wasn't a final decision. We hadn't like 100% agreed. Who knows? We'll just have to see how it plays out." And then this is the one for the actual verdict slip for count 3, just 2 choices: not guilty or guilty of the offense charged, leaving the scene of an accident resulting in death. Now, here's another thing you guys might have some questions about. You might think, well, why, if they were hung on the some of those second charges, well, why did they decide not guilty on count 3? Well, they could have decided that they didn't think she knew she hit him. So leaving the scene of an accident would be not, leaving the scene of an accident causing death would be not guilty, even though they thought she inadvertently hit him, but she was driving drunk and that caused his death, so you would still get some sort of guilty verdict on count 2, the lesser included offenses of count 2. Because initially you might think, well, I don't understand how they hung on 3. I mean, how are they not guilty on count 3, not guilty on count 1, and still hung on count 2? And that's the only way I can think of, is that some jurors must have, um, based on what is being reported, some jurors must have thought, or the jurors must have agreed that she didn't know she hit him. Like, if
Right.
she hit him, she didn't know it.
Right. I mean, like, and we all said, like, that second degree murder was an overcharge. It should never have happened, which leads me into Lynn's question here. Do you think Karen would change her plea to guilty to manslaughter? Or she wouldn't have to change it. You mean, would she plead out to guilty? I think,
No,
look,
it's 20 years.
yeah, it's, well, up to.
Right.
So it's like, when they're coming on this, well, you say that, but if it's accurate as to the count on that manslaughter,
Maybe
you
if
know,
they
if
if they
they
offered
can get,
her,
right, if they can get some movement off of that deal onto a lesser
like,
degree,
what,
or,
3 years, a year and a half, you think she'd do it?
I mean, if you've got,
I think that they're also saying that they were hung up on the lesser included, it seems like, is what they're saying. So not that would only be involuntary manslaughter.
right,
And
yeah, I don't know. It's tough because it's like I am of the mindset that Karen Reed has no idea whether or not she hit him. Like, I don't think that she knows. I think as we sit here today, I still don't think that she knows 100% whether or not she hit him. I don't think she intended on hitting him.
probably pretty sure now, because she's convinced that the evidence shows a car never hit that body.
Right.
So
Like,
she was
so,
at some point unsure. Um,
right. If she found Rentschler as convincing as I did, then she's
Right.
like, yeah, I didn't hit him. Like, thank you, sir.
Julie
So,
Riley, why wouldn't Bev insist on the form being filled out to indicate if all or some of the verdicts were agreed on or deadlocked?
it's a $1
And
million question.
and it's not that the form doesn't have a spot for hung because they don't want jurors coming back hung, but she could have asked them to write back, whether they were, which charges were they hung on all charges, and or which charges had they come to a verdict on, or something to that effect. She could not have asked the split, that's coercive. Um, but and again, she could have given that instruction that I read out from that, um from the I think it's Figura, I forget, I closed it down now. Um, Case about, okay, if you have either decided not guilty on manslaughter or are unable to reach a decision, move on to the lesser includeds. And then when they, report back, um, they could have.
Yeah. And Jen P, member 5 months. Thank you very much. We love having you be a part of the fam. I can hear Bev's sighs all the way from Chicago. No, there's no doubt about this. Like, I'm inclined. Like, I don't think she's going to grant this motion. I just don't. I don't think. I think she's going to be very, very opposed to dragging the jurors back into that courtroom again after a 10-week trial. I think the defense is going to have a very steep uphill battle. I know that may not be what people want to hear, but I mean, we're always just
And
going to give you
that's why I kind of
opinion.
think, sorry,
Go ahead.
sorry, babe.
Go
That's
ahead.
why I kind of think that they should have put in the alternative that the judge decide there was insufficient evidence on count 3, on count 1, and bar retrial on it. I don't know that she could do that on count 3 though, and I don't know that the defense would be
Wait,
happy with that.
so you're saying that there should be language on there, or there was insufficient evidence?
That the judge should find there's insufficient evidence to proceed on count 1. And if she's gonna deny inquiring anyone, like, that could be a way, sort of, that could have given her an out on count 1, because Massachusetts law does allow to bar retrial, and in essence, even though double jeopardy doesn't attach, but to bar retrial if there's insufficient evidence on that
Well,
count.
I mean, so that begs the question to me, at least, is like, I mean, she heard that argument and she
Right.
denied it, but
Right.
can she take into consideration that an impaneled jury deliberated on it for a long time and came back, can that help her reflect on whether or not there was insufficient evidence? I
I
mean, that's the
believe it
question.
can. It is an issue that they consider when, like, when they're considering, the verdicts is how long did it take the jury to deliberate when they're trying to decide, was the jury confused? Was the when you bring up these, like, bias, something was, outside influence, pressure, whatever, you can bring up the length of deliberations as something showing that they were struggling to find that the state had met its burden of proof.
Yeah, no doubt. Always give her Jen coming down with
Wait,
another 5
Tracy,
DDs.
did you say
I
Tracy?
think we did I did Tracy
Okay.
early.
Thanks,
And
Tracy.
I think, yeah, thanks again, Tracy. And so Jen had given 5 DD podcast memberships earlier. So that's 10 for our wonderful mod and fam member. Thank you so much for your continued support, Jen. We adore you. And Sarah Brown coming in with a $2 help. Thank you for taking the time to discuss this. Thank you for hanging with us. And I mean, people just don't want to let this case go. You know who wants to let this case go? Judge Bev. Like, she does not want anything to do with this case anymore. Like that comment about, the sigh heard around the world. She was not happy when this shit came out. It's like, and it's a sticky issue. It really is. I mean, if we're trying to get, just honestly what happened here, I feel it's incumbent upon her to get them back in there. Just find out. The problem is now we know they have a text thread. Now they've probably been bickering for another however many days it's been since she declared the mistrial. I mean, they're probably still deliberating. I mean, like what they said then may not be the case when they finally get back in there if they're all still texting each other. And there's nothing prohibiting them from watching everything that's out there now. You know what I mean? It's like they're tainted. The taint team is going to have to come in. Or did you, like how much shit did you watch? How many YouTube channels did you watch? How much coverage did you watch after this? And are you still of the, like, it's like you're trying to turn back the hands of time, which I think this is going to fall on deaf ears. Like, I honestly do. And I think but the reality is that Lally needs to drop that bullshit overcharge. Like, if he's got his wits about him and he wants to proceed on this thing and get like at least have a better chance of getting a guilty on it, he's got to get rid of that second-degree murder. Like, that just it's like off-putting because it gives the jurors the impression that the state doesn't even know. Like, we're saying we think it's murder, but maybe it's manslaughter. Maybe she intended it, but maybe she didn't. It's like automatically that puts the jurors at odds with whatever the state is thinking happened here. And when you're trying, like both sides are in this, to sell a theory, if you're giving them two theories as to one, well, she did it purposefully. She hit him intending to kill him, or she hit him, knew she hit him, and she left him, which she knew would result in his death or great bodily harm, one of the two. Or she didn't know she hit him, then she grazed him, but she left him anyway. It's like, and she was drunk, shouldn't have been driving. I mean, like those two concepts conflict with one another in the minds of a normal person. It's like you're saying, well, the state's saying both things here. Which one's right? Do you want to read it?
Yeah. So Ashley Lovelace says Bev should have done her job correctly and fairly in the first place. This is on her. She was too worried about getting to the Cape for the summertime.
I mean,
I will say that Bob and I do think what would be best is to bring the jurors in to find out the truth, to ask them, you've got to do it in a way that they don't feel any pressure. And, we just are worried the judge might not do it. I think that there is some basis here for her to do it. She did not give them the opportunity to be, heard. They have cited some case law that just not objecting is not the same as, opportunity to be heard. But, we're just noting some things that could create issues that we don't see what would be the fairest, and that's to find out, what really happened. And I do think that if some jurors, honestly, I think if some jurors feel like, no, 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 we were not really in agreement, we hadn't really made that decision, that they're going to reach out to the Commonwealth and they're going to let them know. Um, so we'll have to see if we are hearing any reports like that, tomorrow. Um, and then Nancy says this case, Nancy Van Orden. Thank you for the
$5
$5.
holla. Woo!
This case was a mess from the get-go. Did we honestly believe that something like this was not going to happen? It just seemed like the jurors were really intellectual about it with those notes. It
Yet
does
couldn't
surprise me.
figure out if they'd really reached 12-0 verdicts, not guilty on the first and the third. How, that's the problem I'm having. I can't wrap my mind around the fact that you've got a four-person that's writing that note that said that all of these people were, for the most part, discussing this thoroughly, with solid arguments, and they just agreed to disagree on things, that it didn't really get heated. I mean, there's the one comment about the bullying, but I mean, it obviously wasn't to the extent that it forced people to
Exactly,
reach a verdict that they didn't want to.
and that's
So,
when that comes into play.
right. So yeah, I mean, what Allie and I are saying here is that we think that the right thing to do, just so it's clear, is that she calls them in, and they have a little bit of an inquiry with the jury to find out. And the question has to be, they have to agree on what the question, because it has to be very simply, at the time that I gave you the charge, and after you went back into the courtroom or into the deliberation room and you came back, were you still 12-0 on, or were you 12-0 on counts 1 and count 3? Because she can't, if she starts trying to dig into if they've changed their minds, because the jury's going to know, because they take the polls over and over and over again. Let's take another poll. Let's take another poll. They'll go around the table. They'll make arguments. Let's take another poll. Let's take another poll. So, I mean, they're like, a juror is not going to be able to come in there and lie about it. Like, if at that point, after the Tui Rodriguez charge, if they went back and she asked a question after I gave you the charge and you went back and you deliberated, you continue to deliberate, I'd ask two questions. I'd ask, one, had you formed a unanimous verdict as to counts 1 and 3? And then two, did the fact that the count 2 existed confuse you as to why you didn't fill out that form? You need to kind of figure out why they didn't fill out the form.
Right.
You know what I mean? You really kind of need to know what happened there. Because you want to hear that excuse. You want to hear that it's a viable explanation as to why they didn't fill out that damn form. Because it's super easy. I'm telling you, the answer lies not in the verdict slips, but in the jury instructions. That's where it lies.
So do you want me to pull up the thing about Proctor? We can do that real quick.
Oh yeah, we'll do that, and then we're calling it. Kitty C313, $5. Wouldn't defense assume that Bev did ask? Has to be on her. Well, she shouldn't have to assume it. It would be on the record in open court. She couldn't have gone back. If you're talking about when she talked about I'm going to be back with y'all and I'm going to discuss some things. I don't know. I don't know if you were here, Kitty C. I imagine you were, but if the jurors told Judge Bev that they were NG on 1 and 3, and then she decided to nip that in the bud and keep it to herself, it's a big problem. It's a really, really big problem. It has to be on her. Allowing Alberts was another bad call. Bev Snippy and jury may be scared to ask if 2 NGs count. I mean, it's not about her though. You know what I mean? It's you could be right though. She's not going to be happy about the concept of dragging these people back into court. And I'm talking about the jurors. That's
right.
Damn.
All right. So let's see what these guys said. And hopefully, if it doesn't, if my sound's not working, we're gonna have to figure it out. Oh wait, the sound's off right now. That's not.
It's in slow-mo. Wow.
Okay.
South Boston.
County DA's
Can you guys hear that?
Yeah, we could hear it.
Oh, okay. I made it small. We're gonna make it big again. What happened? Is it big for you?
It's big, yeah.
detective unit in here to the South Boston Barracks. That's where we are, and that's where you can see dozens of demonstrators are right now as well, many of them holding signs calling for Proctor to be terminated, some also calling for other state troopers to be disciplined as a result of this as well. Now, it was last month that Michael Proctor took the stand in the Karen Reed trial, and it was there where he admitted to texting with friends and coworkers a number of offensive messages about Reed, the subject of his investigation. And at the time, Proctor said he regretted those texts. The governor also saying she was disgusted. Well, today, a board of 3 state police troopers disciplining Proctor and said he should be suspended without pay. Colonel Jack Mon accepting that board's recommendation, making it effective immediately. Now, an internal affairs investigation is still underway, and at the conclusion of that, the department can pursue further disciplinary charges, which could consist of termination from the department. Now, back here live, you can see the demonstrations here ongoing. We've seen signs calling Proctor a misogynist and a bully. We've heard a bunch of people beeping their horns as they drive by here where we are on Day Boulevard in South Boston. Now, we spoke with the former longtime member of the Canton Police Department, a member of that department for 35 years. We'll hear what he has to say about all of this coming up at 6. We're now live in South Boston. I'm Peter Eliopoulos, WCVB News Center.
So he was suspended without pay?
Yeah. And
So
I don't
how
know
long?
if anyone else.
Indefinitely? Like, what was
Hold
the?
on. Sorry. It's like, what is this thing doing? I don't know if you could hear that. I don't know if there was more to this that other people know, like if more information came out. And then did we answer these questions? Why wouldn't?
Yeah, I was telling you guys, like somebody asked it like a couple of weeks ago. Like, you know, it's tough. It's tough to fire cops. They have a union. Cop union is very powerful. Everything is collective bargaining agreements. There is no, like, that's what I was telling y'all. It's like they're not just gonna fire them. Like, they're gonna have to go through this process. So does anybody know? Was it suspended for how long? Indefinitely?
Indefinitely. They just said indefinitely.
Okay, well, that's
What do you think JD's
super.
question's going to? Because I think it was before when we were talking about the jury.
Who exactly is they? JD, fill it out, flesh it out for us a little bit. I don't know.
In a regular chat,
Yeah.
who would be in the room?
Yeah, you
I think we're talking about when the judge went back. She said, you guys wait back there. I'm gonna come back and talk to you. So they would be the jurors talking to the judge at the end after they were dismissed. And I think that's what she's.
And I don't think that would be on record either.
No. Not as far as I know. I mean, maybe it is, and it's something we never see, but I know the judges always do that, and I've never seen it. And Tracy Fagan asks, I remember Bev said, don't tell me the count in your notes. And again, we're not saying that she should ask the count. Bob's like, don't tell me the count. I just want to know which counts are you hung on. Not that when we say the count here, Bev's talking about the split count, not the charge count. But what I was wondering was there more information about what they discussed as that he was disciplined on, or do we just know he was disciplined? Because I wonder if it was for more than just the text.
JD with the $10 haul. I keep wondering how Proctor learned the info on KR's health issues anyway. I mean,
the Alberts and the McCabe's, I'm assuming.
Yeah, and or
when she said
she did her section 12 and they got discovery from the Haas, if they got her medical records and maybe like her, things that she has, like, pre-existing conditions, maybe like something like that. I don't know.
What they asked for in the beginning, my 3 sons, was the jurors asked for the CERT report, a police report, and the judge told them that you have all the evidence that there's nothing more. So I don't know that I do either, Kaylee. Kaylee doesn't believe for 1 second the suspension was only because the text messages. She thinks there was more discovered.
Got a $5 Venmo from Catherine H. Appreciate you and Allie so much. Thank you, Catherine. We appreciate you so much. We really, really do. All right, that's it. We're calling it. I want to eat. You got anything else though? Like in all
No, but Travis, and thanks, Travis. I know you sent me some case law about post verdict voir dires and challenging the verdict that came in while I was doing my own research, so I didn't have a chance to look at. But Travis says today was only an interim hearing called a duty status hearing, but his duty status will be pending the completion of the investigation and disciplinary hearing.
good intel. Good intel, Travis. Thank you, man.
Right,
Not
and
record.
that really is correct, as far as I know, Rocky, that there's not a record. The judges just goes back them and thanks them.
Yep.
She's not supposed to be asking about deliberations. That's all accurate and true. So that's why I'd be, like, surprised if that came up, but, you never know.
Thanks, Kai. Member for 2 months. We appreciate you. We love having you as fam. Yeah. So thank you to our mods. We were live earlier today. Again, double duty. So we always appreciate you more than you'll ever know. You guys are the best.
Don't forget to hit that thumbs up before you
do
minimize
the like
the
thing.
chat.
What's our check? We were around like 550, 560 at some point. Like what's our count? Like how the likes looking? So yeah, like, subscribe, share. It helps get us out to the world. And we appreciate that very much. And it's free. It's free to do that. If you really like the content, become a member. That costs you a little bit, but it helps support the show. And we're very, very grateful for all that. So
We got 410 thumbs up, so we're doing pretty good.
I'm doing great.
People are doing good.
Killing it. They're killing the thumb game. So, and if you guys didn't hear, if you're coming in late, Jay, Allie and I will be covering Alec Baldwin together. And we will be rejecting all Karen Reed questions during the coverage of that trial. So just make sure that you guys know that we're not.
And wait, because JD asked this question. Thank you for the $10 holler, because we asked her to put it in chat, and then I don't know if we checked. So sorry that you paid again. I mean, who would be in the room now if the judge called the jury back in? In theory, it could be the judge and both lawyers. But it's possible that the judge could say, I want to just be me and the court reporter, and the lawyers would not disagree with that. I mean, the defense wants the jurors questioned, no matter what. But if that was like a give and take that they had to give, but in theory, it would just be the judge asking the questions and the lawyers kind of watching, or the lawyers not being there at all. And yes, it would absolutely be a court reporter would be there now. And it would probably be juror by juror, one juror at a time, be questioned in chambers outside of the presence of all the other jurors. And I would think if she allowed this, they might want to suggest, look, we would let you do it without us in the room, so they're not feeling any pressure or intimidation to make either lawyer happy, So if it were me, I'd say, Your Honor, I have no issue, with you being you and the court reporter, and they would discuss beforehand what she's going to ask them. That would be definitely something that everybody had input on, and how she would handle it. And when is do you remember when the hearing date is? Because I wonder if that's when this
I want to say the 22nd of July.
Right. And I know that
don't quote me on that, but I think that was the date.
Jackson said he couldn't be there in person. And I don't know if they tried to motion this up sooner or not. And I don't know if Dizzy's in here, if she knows if there was a notice of motion that set this sooner than July 22nd, or if they just filed it without. And everyone is saying, yes, it's July status hearing, July, 22nd. If they tried to set this motion, if they tried to set this motion with separately.
Yeah. Yeah, those are the questions. Those are the good ones. All right. So again, thank you, mods. Thank you all for hanging with us. If you're on replay, thank you for checking it out. Make a comment, throw a comment in, it throws it in the algo. Make sure you like, share, subscribe. And if you love us, why don't you think about becoming a member? Because we love our family. Family members are the best.
I don't know. Melanie asked me to do this with her, as far as I know. So
Yeah, I mean, I'm ready to go
We're
on.
ready to eat.
I'm ready to go on Baldwin. I mean, like, I'm ready to give Karen a break. It was like, but it's like we got to cover stuff that's pressing, and this is pressing. We did
this
what we
is
did. We finally got maybe an idea of the count. It's like all I know is that Yannetti and Jackson relayed the information they were given. The one thing that I know is that they're not making it up. Does that mean that it's completely accurate from where they're getting it? Who knows? I mean, that's one of the reasons why you got to get, I mean, if there's 12-0, like the right thing for all the jurors to do, if it was truly 12-0 on 2 counts, and I'm going to end it on this, they should all be coming forward and say, yeah, we understand that this is, we all, just so Judge, we're going to write a letter, and I'm going to have all the like 4
right.
persons say, you know what? I'm going to go to all my former jurors here, and we're going to sign this letter. And yes, we all did agree. But
Yeah, if they've got this joint text and they're listening and they actually agree with that, they should send an email to the judge,
better off a
the
signed,
DA.
handwritten note signed by every single juror. That's like some in stone shit.
Or even an email, at least.
Yeah, emails could be like, no, man, that's like, I want some old school, like quill, like the inkwell, like the feather.
Well, at least if they all email, they know
they're in Boston. They're
they
in
know who the
Mass,
person
for God's
is.
sakes.
Anyone can sign a piece of paper.
Anyone can write an email with a fake
Well,
email address.
at least it's trackable to your
Is
email.
it? What happens if they send it from the public library?
Well, then no, that doesn't count.
Boop. All right, you guys are the best. Thank you, because without you, I'd just be an old man.
Talking about a lot of cases.
Thanks, babe.
Hudson.